Good morning from Calgary, Alberta, and good afternoon to those of you who are joining us from elsewhere in Canada. My name is Stefania Litsyuk, and I am going to be the moderator of today's CCAT Symposium session. I am a commissioner at the Canada Energy Regulator, and I'm also a member of the CCAT Symposium Program Committee. I'm very happy to be here with you today as part of our symposium series, Listen and Learn, All the Stories to be Told. I would like to begin today by acknowledging that my office and the head office of the Canada Energy Regulator is located in the traditional territories of the people of the Treaty 7 region in southern Alberta, which includes the Blackfoot Confederacy, which includes the Siksika, Piikani, and Kainai First Nations. Treaty 7 territory also includes the Tsuut'ina First Nation, Stoney Nakoda, including the Chiniki, Bearspaw, and Wesley First Nations. And I'd also like to note that the city of Calgary is home to the Métis Nation of Alberta, Region 3. Thank you to everyone who is joining us today. Welcome from wherever you are. And I would also like to honor the traditional territories of where you are all located as we come together across the country this morning. As you are all aware, the symposium is being presented virtually this year, but that has not stopped the program committee from presenting what CCAT has become known for, a diverse and thought-provoking program that we hope will inspire, educate, and empower all of us participating in the administrative justice community. We understand that all of us are anxious and eager to join together at conferences and at events in person. However, planning an event like a symposium requires a significant lead time, and this planning began almost a year in advance. And there have, as we all know, continue to be uncertainties associated with the pandemic, including travel restrictions and other restrictions that can impact attendees. And as such, we made the decision to maintain a virtual format and welcome you all to this format this year, and also, of course, welcome a possible return, hopefully soon, to in-person future events through CCAT. Before we begin, I'd like to share a few housekeeping details. First of all, for each session, we invite you to find login details for all the CCAT 2022 sessions in your inbox, typically the Wednesday or the day before each webinar. And if you are not finding all of those, please take a look in your spam or your junk folder. And if you are not able to locate your login information, please email the CCAT office at info@ccat-ctac.org. And the email is posted in the chat already. Thank you, Cindy. For those who purchase a full series registration, you will receive the login details to all the webinar proceedings. Our panelists for this session have graciously agreed to record this session, and so we will be able to provide a link to this for as part of the full series of sessions presented as part of this year's symposium. We are also pleased to provide simultaneous interpretation services for the webinar series. To activate this feature, if you have not already done so, there is a simultaneous interpretation button located at the bottom right-ish part of your screen. There's an icon that looks like a globe and says interpretation underneath. You can select your preferred language, either English or French, to have a continuous stream in the language of your choice. And you can select mute original audio as well. We welcome and hope that you will actively participate in all of our sessions, and in particular in today's session. There are a couple of options for you to join the conversation. You can post questions in the Q&A, and there's also the chat function. Those buttons are located at the bottom of your screen. The Q&A, if you could use that to send questions to panelists, we'll be watching for that. You can also upvote questions, something that I've never done, but I'll be interested to watch today. And you can also engage with your fellow attendees through the chat, either as a group or individually. We really enjoy seeing your thoughts and you sharing any resources or relevant links that you'd like to share with us. The chat is also a good place to post any technical issues. I'd like to begin today with a brief introduction of our outstanding panelists for our session today on common sense, not so common, question mark, topics of interest to the administrative justice community. And I'd like to begin by introducing Anita Tsigari. Anita is the principal lawyer at Anita Tsigari Advocates. She's the founding lawyer, and her firm focuses on mental health and the law with the assistance of 2 associates, 2 articling students, a legal assistant, and an office manager. Anita's firm is small but mighty. She shared with us a bit of information that is not in the bio, which I invite you all to read, but she indicated that I think she's closing in on 250 Court of Appeal appearances, which just speaks to the prolific work and output of Anita and her firm. And we are certainly looking forward to hearing the perspectives that she brings to this topic. And I can also share that Anita was in part the inspiration for this topic as part of some social media sharing that that she put out on Twitter regarding common sense and tribunals, which led us to dive a bit deeper into that topic. So welcome, Anita. I also welcome Carrie Frock from New Brunswick. Carrie Frock is an associate professor and a recognized scholar, having run both Trudeau and Vanier scholarships. She is not only well respected as a writer of academic articles, but also sought after in the mainstream media as a commentator on legal issues. Before completing her doctorate and teaching as one of her courses, administrative law at UNB, Carrie spent almost 20 years as a lawyer, including a civil litigation practice in Regina, as well as acting as a staff lawyer for the Women's Legal Education and Action Fund. And I'm excited to hear Carrie's contributions today as well. We also have Walter Pilipchuk. Walter joins us either from Alberta or BC. He splits his time among family in both of those provinces. And Walter brings to today's panel a wealth of experience as a retired adjudicator with 2 provincial tribunals in BC, both the Labour Relations Board and the Provincial Human Rights Tribunal. He's also spent years providing advice to tribunals as legal counsel. So he has practiced law for over 40 years before, as he describes it, achieving full retirement, although that was a gradual process as he explains it. And he has been involved with CCAT for many years, and we welcome him, providing both an adjudicator's and legal counsel perspective. J'accueille aussi aujourd'hui José Audet, juge administratif avec le tribunal administratif du travail au Québec. José est membre du barreau depuis 1988. Elle a pratiqué le droit dans le domaine d'indemnisation des accidents du travail durant plus de 20 ans. Elle a été nommée adjudicatrice en 2013. Et elle décrit que c'est une fonction qu'elle occupe avec passion. Nous sommes très contentes de l'avoir avec nous. Elle est également chargée de cours à l'Université du Québec. Donc, nous avons encore un autre prof parmi nous pour partager avec nous des connaissances qu'elle a accueillies comme avocate et comme juge administratif. With that, we are going to begin today's format with a debate-style introduction to the question of common sense. And I can share with you that we have a passionate group of litigators, former debaters, and adjudicators today who have generously decided to adopt positions arguing for and in favor of the application of common sense to a greater degree and its merits within adjudicative processes, but also not so much against common sense, but highlighting the perils of being overly or perhaps lazily using the concept of common sense, both as a lawyer and an adjudicator. We're going to have, as our debaters for common sense, Anita, who kicked off this, as I said, this concept for us today. And Walter will also be on her team. And then speaking to the perils of common sense, we have Jose and Carrie. So with that, welcome, as I said, to our outstanding panelists. I'm really looking forward to hearing from a brilliant group and all of your insights on the concept of common sense. With that, Anita, I turn the floor to you.
Thank you. And just before I launch into the debating bits, I did want to pause for a moment and thank you to Stefania and to the organizers for involving me in this very thought-provoking and absorbing exercise of reflecting on common sense. I'm very, very happy to be here. So let me just adjust my screen for a moment and see. Oh. There we go. All right. In favor of common sense. Common sense gets a bad rep. Indeed, there's a frank hostility toward the use of common sense in judicial decision-making. Common sense is denounced as arbitrary, biased, random, and offending the rule of law, somehow displacing reasoned decision-making or reasonable decisions based on the evidence before the tribunal. This is a complete unfairness to common sense. Common sense serves a useful and necessary component of administrative decision-making. Common sense is good sense. Common sense does not displace the need to base tribunal decisions on the evidence. Of course, a tribunal will never be able to hear all of the evidence that could be called in a case. The administrative agency is an expert tribunal that is infused with special knowledge owed deference. It is to employ that expertise in its decision-making. It should do so in a way that makes good sense, common sense. Common sense does not mean overriding parties' legitimate concerns and reasoned arguments in favor of a populist sentiment or a politically correct or currently held view. Common sense does not mean displacing the evidence heard by the tribunal in favor of personal preferences or subjective views or beliefs about the world. Common sense means infusing adjudication with impassioned reasoning. It means taking a functional and practical approach to decision-making. It means considering the importance of the issues before the hearing panel when determining the issues or procedures to adopt in each case. Common sense may inform the ultimate decision, but it must inform every step of the adjudicative process, from scheduling to how reasons are written. Common sense should guide the scope of the hearing and what evidence or arguments are heard and entertained. Where there is an evidentiary gap that cannot be practically filled within time constraints, the tribunal is entitled to use its common sense to determine next steps. Employing an inquisitorial approach may be what common sense requires in the contextualized circumstances, or in other cases, further evidence will not be necessary because the tribunal has the necessary expertise to make a sensible, reasonable decision, one that is obvious and clearly does not fly in the face of reason, one that a reasonable person apprised of all of the relevant law and circumstances would find acceptable and sensible. Decisions supported by common sense make good sense and ultimately amount to reasonable and reasoned decisions. Beyond substantive decision-making, however, common sense has its greatest role in procedural justice and fairness, particularly where vulnerable litigants are concerned. A rigid insistence on consistent application of a tribunal's rules, even rules that were enacted to enhance access to justice, can result in manifest unfairness. A decision maker should reflect carefully on each decision they make and its immediate consequences for the process and the impact on the rights of litigants, particularly where the stakes are high. Stop and consider. When you make this decision, this is what will happen next. And then ask yourself, in effect, what a reviewing court will ask. How much sense does this make?
Thank you so much, Anita, for speaking as our first speaker in favor of common sense. José, I will turn to you next.
Merci. Bonjour tout le monde. Merci. Bienvenue dans ma salle de cours où tous les jours, j'essaie d'agir avec un peu de bon sens. D'abord, je vais faire les mêmes remerciements qu'a fait Anita. Merci à toute l'équipe du symposium. Merci à Stéphania. Merci à tout le monde. Merci de l'invitation. Pour moi, ce n'est pas tant une question d'être pour ou contre le bon sens. C'est une question d'égalité devant la loi. C'est difficile de dire qu'on est contre le bon sens. Personne n'est contre ça. Mais moi, je suis pour le bon sens avec la loi, dans le cadre de l'interprétation de la loi, dans l'exercice de l'appréciation de la preuve en tenant compte de la loi. Pas le bon sens à la place de la loi, pas le bon sens en haut de la loi, parce que je pense que les dangers de glissement sont trop grands, parce que je pense que cette notion-là est trop personnelle à soi et à son vécu et risque peut-être de faire place à de l'arbitraire. Parce que ce qui correspond au bon sens pour moi et ce qui correspond au bon sens pour mon premier mari, c'est vraiment pas la même chose. Ou encore, il y a des gens qui disent « c'est bien plausible l'histoire de cette personne-là, ça a du bon sens parce que ça m'est déjà arrivé à moi. » Je ne pense pas que tout ce qui est déjà arrivé à une personne est le premier critère d'interprétation de la loi. Il y a une loi aussi pour ça, c'est la loi d'interprétation. Et elle inclut des principes qui réfèrent à la logique et au bon sens. Nous avons eu à notre tribunal, le tribunal administratif du travail, à trancher des litiges suite à des demandes de retrait préventif en lien avec l'exposition à la COVID-19. La pandémie n'avait certainement pas été prévue par le législateur en 1979. Mais nous avons interprété la loi en utilisant les principes d'interprétation et en utilisant les enseignements de la Cour suprême en matière d'interprétation moderne. Et donc même, dans cette situation sans précédent, nous n'avons pas eu à sortir du cadre de la loi. En fait, le bon sens est à la base de la loi, à mon avis. D'abord, on l'utilise, cette notion de bon sens, dans notre travail quotidien d'adjudicateur qui doit s'effectuer dans le respect de la loi. Parfois, certains principes relatifs au bon sens sont également inclus dans la loi et dans la jurisprudence. Par exemple, en matière de procédure, les lois que notre tribunal applique et interprète prévoient la possibilité pour une partie d'être relevée du défaut d'avoir fait une réclamation ou une contestation dans les délais si elle fait la démonstration de motifs raisonnables. Donc, c'est un peu comme si l'utilisation du bon sens était prévue dans la loi même. Dans la loi, on lit « motif raisonnable » et notre jurisprudence constante a interprété cette notion de motif raisonnable comme étant un motif non farfelu, crédible et qui fait preuve de bon sens, de mesure et de réflexion. Tout comme le critère pour la révision judiciaire de nos décisions est souvent celui de la décision raisonnable, qui a été défini par la Cour suprême comme, eu égard au raisonnement sous-jacent, une décision qui, dans son ensemble, est transparente, intelligible, justifiée. Quand on évalue la crédibilité des témoins, on se sert du bon sens pour décider si on va, par exemple, ou non, retenir une version des faits. On le dit à nos collègues pendant les pauses, ça n'a pas de bon sens, son histoire. Le travailleur, il décrit son accident du travail, c'est comme s'il avait fait un triple loop avec 50 livres de matériaux dans les mains. Ça n'a pas de bon sens. Je ne retiendrai pas sa version des faits. On va aussi faire preuve de bon sens en rendant nos décisions rapidement, parce que les gens les attendent, et en les transmettant en des termes compréhensibles et accessibles pour que les parties les comprennent. À cette fin, notre tribunal, à l'instar de nombreux autres tribunaux, a adapté une nouvelle méthode de rédaction des décisions par question en litige qui permet de rendre des décisions plus concises, écrites clairement et dans un langage à la portée de tout lecteur. Et tout ça dans le respect de la loi.
Merci, José. Comme vous avez dit, c'est difficile de nous donner des soumissions contre le bon sens, mais quand même, on l'apprécie. I'm going to turn now to Walter to continue speaking for common sense and to engage in a little bit of rebuttal if you wish before we finish off with Carrie.
All right, thank you very much. So I'm going to say that I'm in, excuse me, I'm in favor of common sense as a factor or an underpinning to our whole legal system. I think common sense, our whole legal system is based on common sense as a reaction to what went on in the good old days that you may remember: trial by fire, trial by drowning. Somebody drowned, they were innocent because God accepted their soul. If they survived, they were guilty, so they were killed anyway. You know, those good old days when the earth was flat. So I think our whole system was a reaction to that kind of bizarre approach to justice. A working definition of common sense, as I would see it, would be a basic ability to perceive, understand, and judge in a manner that is shared by nearly all people. Now, I say that a little bit tongue-in-cheek because, of course, today we live in a world post-Trump, where fake news and living in bubbles and creating your own facts seems to be the norm. To Anita's point, while some authorities and some judges may give common sense a bad rap, there's a lot of case law that gives common sense its proper due. Often the phrase is used in combination with words we've already heard both from Anita and Jose. You see phrases like reason and common sense, logic and common sense, product of personal experience and common sense and knowledge of the world, those kinds of phrases. Ordinarily and commonly done under similar circumstances as reflected in common sense. So, you know, those are the kinds of phrases you see if you just Google the Supreme Court of Canada decisions. It's also been alluded that common sense plays a role in fact finding, judging evidence, which is absolutely correct. The courts have emphasized that the basis for our jury system is rooted in common sense. The very strength of the jury is that the ultimate issue of guilt or innocence is determined by a group of ordinary citizens who are not legal specialists and who bring to the legal process a healthy measure of common sense. The collective common sense and knowledge of life possessed by 12 jurors is of fundamental importance to the unique value of juries. So you see that as juries are the fact finders in a trial. So you see that as being an underpinning for fact finding. And if you go to some old cases out of England, there's a Vice Chancellor, Van Fleet, who said, evidence to be believed must not only proceed from the mouth of a credible witness, but it must be credible in itself, such as the common experience and observation that mankind can approve as probable under the circumstances. We have no test of the truth of human testimony except its conformity to our knowledge, observation, and experience. So you see, common sense is a combination of all of those factors. Another test for credibility that's used out here in British Columbia, maybe across Canada, Farina and Chorney, the real test of the truth of the story of a witness must be its harmony with the preponderance of the probabilities which a practical and informed person would readily recognize as reasonable in that place and in those conditions. Can paraphrase that any number of ways, but what it really says is you look to your own experience, your own common sense when you're assessing credibility to determine what is practical in those circumstances, in that place and in that time, and whether the testimony is consistent with those probabilities. And we've had examples of the triple flip or the somersault that somebody will reject out of hand. So common sense underpins a lot of the legal concepts that we rely on. And given the kinds of descriptions I've already used, I could go on to say that the reasonable person the ultimate test. The reasonable person, the officious bystander, is rooted in common sense. The officious bystander traveling around on London Transit, observing the world, experiencing the world, bringing to bear, as I said in my working definition of common sense, perception, understanding, and the ability to judge what the person sees. So I'm all in favor of common sense. And as this session unfolds, I can give you some other examples of where common sense is very much a significant feature of our legal system. Thanks.
Thank you, Walter. And Carrie, there is no rebuttal formally in all of this, but you, as a result of that, get the final word and rebuttal in today's mini debate. Carrie, please go ahead whenever you're ready.
As I used to say sometimes in court, I like my chances. And I think one of the reasons Stefania invited me is to be a bit polemic. So I'll kind of be, I'll try to do that to provoke some discussion a little bit. But the first thing that I wanted to talk about is, you know, common sense is really in the eye of the beholder. A lot of times I'm reminded by José's comments by something my ex-husband used to say to me. And he used to say, for such a smart person, you sure lack common sense. And I think to myself, well, I think I'm behaving in a perfectly commonsensical way. So, you know, but more seriously, I think we do have to be cautious that common sense doesn't simply mean what's reasonable according to dominant perspectives or according to a decision maker's own kind of idiosyncratic experience. And I totally agree with Walter's concept of common sense, our understanding of human behavior and our experience as human beings on Earth being used to assess credibility and to perhaps assess the weight of evidence. But even you can see in all of the panelists that common sense is really a slippery concept. Anita talked about it a little bit in terms of making sure that the law functions, that it works for everyone, that it does justice to particular participants. I think that's slightly different than what Walter talked about in terms of common sense. José talked about it in terms of fairness, in terms of interpretation of the law and application of the law. And Anita also talked about it in terms of, you know, potentially, unless I misunderstood her, being used to fill in evidentiary gaps or, you know, changing the process. And I don't know if I quite agree with that. And I'll tell you a bit why. I said I was going to be polemic, right? We have to get some sharp edges, our sharp elbows up here. So I want to talk about common sense beyond those global, you know, the global comments about needing to be cautious about what we think common sense is, to get more granular in terms of what it means for constitutional law. And I want to talk about it in relation to two elements. And I'll just kind of give you a teaser or an appetizer, and then you can maybe ask me some more in the questions. There's a question of, you know, we all agree that the administrative state is set up because of the expertise of decision makers. There is a case that Madam Justice Wilson was dissenting in, but I thought it was interesting that she said deference to administrative expertise is grounded on common sense. Because we need that expertise in a detailed administrative regime where you're dealing with highly specialized and complicated subjects. And she said that you need that in order to be able to adjudicate properly. So we're all coming at it with that kind of base level of understanding. We're all kind of specialists in administrative law. We all accept that as kind of the basis for which we do our work. But the question is, first of all, To what extent are you allowed as a decision maker to use your experience and your expertise as a matter of common sense versus it being bias, meaning that you're predisposed to decide things in a certain way. You are deciding a case based on facts or evidence not before you. And it's interesting because I was having a look, and I'm an academic. So when you're an academic, you're kind of a hammer and everything's a nail. So you go look at what other academics said. So there's an American professor by the name of Howard Bruff who talks about administrative law displaying a basic ambivalence about adjudicative neutrality. The benefits of obtaining knowledgeable decision-making are gained at the risk of introducing unacceptable levels of bias or interest. And he says that this tension between expertise and bias has existed for centuries. And Robert Hawkins, who's a Canadian, also was kind of in the same vein, that he said that the need for expertise means that adjudicators who might otherwise present the appearance of bias must be accepted. So I think adjudicators are kind of walking that fine line all the time between using their expertise, because that's why they are appointed, and yet needing to step back a little and be objective and deciding, the interpretation of the law based on, the proper interpretive tools, and assessing the case based on evidence before it. So that's thing number one. How do we figure out the difference between expertise and relying on that expertise to make common sense decisions, and when do you veer into bias? I don't think that there's a bright line. I think that they are always in tension. So how do we, how do courts and how do scholars and how do the rest of us make that distinction? Second thing is about substantive review and making factual assessments. That's changed as a result of Vavilov. The Pavlovian way of talking about it is justification according to legal and factual constraints. And that case kind of holds the line in terms of saying that it's going to be exceptional before a court can interfere with the factual findings, but it will do that where the decision maker has fundamentally misapprehended or failed to account for the evidence. So the question is, again, to what extent can a decision maker rely on common sense? Especially, I would say, my experience is more in looking at professional misconduct and incompetence. That was what my practice dealt with. So how can you rely on common sense, your technical understanding of what a reasonable nurse or a lawyer or a dentist would have done in the circumstances? Again, I would take issue with the idea that you can use expertise to fill in the blanks of missing evidence, or that it can be a substitute for expert evidence. But this is, again, a really fine line. When are you using your expertise to fill in for the lack of expert evidence? Or when can you use your own expertise to make a finding that perhaps conflicts with the expert evidence that you've heard? And when are you simply using your own expertise to interpret evidence? And it's interesting because common sense, even in relation to professional standards, can be very specific and can lead decision makers astray in terms of making unreasonable findings. One of the cases that was occupying my firm and the lawyers that I worked with when I was an articling student is a case called Bailey versus Saskatchewan Registered Nurses Association. And there was a patient who was projectile vomiting. And the question was whether or not he was vomiting what's called coffee ground emesis, which is very bad. It's an indicator of internal bleeding, or did he just have the flu? And the judge at Court of Queen's Bench overturned the findings, finding the nurse guilty, because the committee was filled with acute care nurses, whereas the nurse in question was a long-term care. And the judge said, well, you know, using their own expertise in that setting doesn't translate, and that was stacking the deck against the nurse. So the question is, these acute care nurses were assessing the evidence using their own common sense, but the judge found that that was inappropriate in second guessing the decisions of a long-term care nurse. So these are all kind of slippery concepts in common sense that should give us a bit of pause, I think. And what the way out is, I'm not really sure, because I'm in favor of common sense, and in the way perhaps I'm most aligned with Walter's assessment of it. But I think that we need to be precise about what it means and when it's appropriate to use. So sorry, Stefania, I think I went over 2 minutes quite a bit. You know, I'm long-winded, but there you have it. Thanks.
Thank you so much, Carrie, and no problem at all. There's a couple of questions and comments that have come up that I'd just like to speak to before we carry on. First, we've already started to refer to some prior cases. Carrie, you've noted. I would like to share with all the attendees that our panelists have crowdsourced a reading list that will be shared, and we will endeavor to make sure that any cases that are mentioned today or resources that are mentioned today are on that if they're not already on the list that I have compiled. There's definitely a lot of rich reading around common sense, and I think this panel, once we were assembled, all started to read about common sense because it's a fascinating concept. And Walter, you started talking about some of the definitions or descriptions of common sense that exist both in different jurisdictions and in different decisions. I'm just going to invite our other panelists whether to sort of offer us a one-floor elevator definition pitch of what is common sense in brief. In my reading, my favorite definition of it was, you know, that regularly borrowed phrase, I know it when I see it, but it's not always easy to pin down a concise concept of what do we mean by common sense. José, how about I go to you first with.
D'accord. D'abord, ça dépend à qui est-ce qui parle. En droit, quand on réfère au bon sens, on parle d'un raisonnement justifié, intelligible, transparent. On a référé longtemps au bon père de famille, mais ce concept-là n'avait pas de bon sens non plus, alors on l'a changé pour la personne raisonnable placée dans les mêmes circonstances. En philosophie, le bon sens, c'est ce qui comblerait le vide entre la sphère théorique et la sphère pratique. Quand dans la sphère pratique, il faut agir. C'est la saine et droite raison. Descartes dit que le bon sens, c'est la chose la mieux partagée. Autrement dit, ce qui a du sens pour le plus grand nombre. Mais ça peut apparaître facile de dire ça parce que pour un très grand nombre, mais ce grand nombre-là est formé de qui? Dans la société actuelle, tellement hétérogène, remplie de pensées tellement diverses, qu'est-ce qui est censé pour le plus grand nombre? Est-ce que ça ne va pas dépendre de qui ce grand nombre-là est composé? Je pense qu'on a une partie de la réponse quand on considère un peu ce qu'on trouve qui n'a pas de bon sens. C'est une expression très utilisée en français. Ça n'a pas de bon sens ou ça a bien du bon sens. Parfois, on va dire ça en fonction du résultat. Par exemple, ce dossier-là a procédé 2 ans après les événements, ça n'a pas de bon sens. Ou la conclusion qu'on dit que ça n'a pas de bon sens peut concerner aussi le processus. Par exemple, comment ça, une ordonnance de non-publication? Personne ne va savoir ce qui s'est passé? Ça n'a pas de bon sens. Ou à l'inverse, quoi qu'il arrive à l'audience, madame, vous n'aurez pas à rembourser les 2 ans de prestations que vous avez reçues, à moins que vous ayez été de mauvaise foi. Ah, ça, on trouve que ça a bien du bon sens. Alors, mais toutes ces situations-là, elles résultent de l'application de la loi. Parfois, notre conclusion qu'une situation n'a pas de bon sens va venir d'une source qu'on est capable d'identifier. Par exemple, ça n'a pas de bon sens 2 ans, c'est bien trop long, puisqu'un des objectifs de notre loi, c'est la célérité. Parfois, notre conclusion que ça n'a pas de bon sens, elle n'a pas de raison claire. Et ça, c'est intéressant. On dit ça n'a juste pas de bon sens. Ça doit se dire en anglais, just doesn't make any sense. Mais on n'a pas vraiment de raison claire. C'est comme si notre sens de la justice était heurté. Comme par exemple, deux collègues juges qui discutent et qui disent, mais à mon audience, mon litige était clair. C'était la révision de la base salariale. Mais là, le travailleur voulait revenir 3 ans en arrière et revenir sur ses séquelles physiques, mais je ne peux pas toucher à ça. Mais en même temps, ça n'a pas de bon sens. Il y a aussi le clash entre la théorie et la pratique, la théorie, les beaux principes, et la pratique, leur applicabilité, qui va souvent être invoquée pour tenter de démontrer qu'une règle n'a pas de sens. Rappelez-vous l'époque du confinement obligatoire. Les gens disaient, ben, voir si les policiers vont commencer à aller dans toutes les maisons. Ça n'a pas de bon sens. Alors voilà.
Merci, José. And just following up, I think, on the question of super theoretical versus ultra applied science of common sense. Maybe I'll turn to you, and Anita, and you, Carrie, because in terms of appearances before tribunals and legal practice, what's your distilled definition of common sense in our administrative law sphere? What's your perspective on that?
Thank you for asking that. Yeah, I really try and veer away from the theoretical when on my feet, or these days, on my butt, sitting in Zoom hearings. And I really try and focus on the practical of what's happening. So I did reflect quite a bit on our topic today after our initial planning session, when I realized that I didn't understand the topic I had inadvertently proposed. So I thought about it a lot. And what I distilled it down to in the end for me is an appreciation of cause and effect of the decision making, very simply put. So if a decision maker asks themselves and genuinely appreciates why they're making a certain decision, the cause for making that decision, why are you making this decision, and the effect of that decision. If you think through logically and practically, I'm going to make this decision, what will be the practical impact on the litigants, the parties before me, and in particular with specific emphasis and special emphasis on what will be the impact on the vulnerable litigant, if there is one, in your context. I think it would prevent a lot of train wrecks if you just focused on that, because I think what is happening in the hearing room often is this rigid application of particular rules. This is when we stop the hearing. This is the time we've allotted for this. This is what our rules require. Where's your formal motion? You haven't filed this piece of paper. We can't therefore hear this issue that you're raising now. If you just stop and ask yourself, if I rule against this person, I don't hear this complaint, what is going to happen to this person? Is there a liberty infringement that occurs? And is it something that I can prevent by simply saying, we're going to make an exception here. We're going to hear you on this because of how important it is. And I think for me, it all boils down to cause and effect of that decision. So that's where I got to, profound as that is. That's where I got.
Thanks so much. And over to our hammer on the panel, Carrie, in terms of from the academic view, any thoughts on this? And then I'm going to move into the bias, just to give the panel a heads up. There's a very good bias question in our chat, and I'm going to come back to that, but I don't want to close out without hearing from you, Carrie.
Yeah, and I think looking at a case like RDS, which was what it was about bias, and it was Black Judge Corrine Sparks talking about, in her experience, police tend to overreact when they're dealing with members from the non-white community. And that was based on her lived experience, as a Black person living in Nova Scotia. And I think that's the best use of common sense is human experience, your experience living in this world. It speaks to the reason why we need a diversity of people on tribunals and on courts. But looking at your own human experience, using your expertise to make assessments about how things work. That's not a very academic definition, but I think it's a good rule of thumb. And I think that when it comes to using common sense to assess credibility, I think that decision makers need to approach that with a little bit of humility. I was watching something about traditional police practices during interrogation the other day, and it was talking about the fact that cops have all of these like little tricks to try to figure out if someone's telling the truth. Like you look them in the eye, and these are very, very old interrogation techniques. But what the studies show is that police, their ability to tell when someone's lying is no better than chance. And in fact, I think other studies have shown that even school children can do a better job at determining whether or not someone is lying. So there has to be a certain amount of humility and reticence to use your experience from your own community with your own characteristics to try to assess the human condition as far as credibility is concerned. So I think there's that element too, is that what should be excluded from common sense.
And you're definitely bridging us into our next topic. And we have a question from Paul who queries how we can add to the officious bystanders many admirable characteristics, a degree of self-awareness and appreciation of their own bias and perspectives that they are bringing to the table. And I ask that as, you know, somebody who has a statute that specifically reminds us to take, for example, Indigenous knowledge into our decision-making and recognize formally that a nation-to-nation environment in which we are making decisions. That's one challenge that, you know, I live day to day. And I know that there are others. So I'm curious to hear thoughts from the panel about, you know, how do we as decision makers recognize our perspective and identity in terms of how it's affecting our view of common sense? And for those who are practicing in front of tribunals, how do you effectively bring that to the fore so that it does not get overlooked as part of the decision-making process? So, Carrie, we've heard a little bit from you. I'm just going to turn over maybe to you, Anita, first, and then hear what you have to say on that topic. Because Carrie, I think you've started us off already on this in terms of appreciating the frailties of how much we can bring to common sense.
Sorry, you just faded a little bit in and out for me because my connection was weak, but I think we're talking about the dangers of bias and our own expertise as adjudicators and experiences we bring to such issues. So I do want to comment on that. And I enjoyed the debating style of our opening, and I just wanted Carrie to know so she doesn't leave this session thinking that I meant what I said when I was debating that part of things. I don't think adjudicators should be filling evidentiary gaps based on, you know, certainly their own views of things, although, you know, there's certainly a role for some expertise, which is why we have administrative tribunals. But this actually leads me to something I was going to touch on with the next question. But obviously the dangers of relying on common sense and substantive decision making, and where credibility is an issue, are I think much higher than when we're talking about procedural fairness, for example. So implicit biases will come into decision making under guise of common sense when we're making substantive decisions. And perhaps I'll just give this example now from my line of work, and maybe it would be helpful. I represent clients who have very serious mental disorder. I represent them in criminal justice and in the civil stream. Canada's largest psychiatric hospital, actually, after they had a lot of people go AWOL and there was public massive outcry, they revamped how they approached increases in privilege ladders. And every single inpatient who's a not criminally responsible accused or detained in these hospitals had to start the privilege ladder by going into a secure yard with a high fence, accompanied by 2 uniformed security guards. And otherwise you could never gain any privileges. So we were at a hearing, I complained about the process and how my client was stuck and couldn't get any privileges or access the community. And the evidence from the other side was, well, we've offered him to start, but he won't go in the yard with security. And my tribunal chair said to me, he cut me off complaining and said, this is your client's own fault. They offered him, he can go anytime. All he has to do is go. I don't know what you want the hospital to do about it or us to do about it. So my tribunal chair was a retired judge, you know, thoughtful, wonderful man, but an older white man. I had an all white panel. My client was a young, dark-skinned Black man with a long history of police contact. And his relationship and his experience with uniform security and guards and police, he would not and could not take that initial step. So just one of them, you know, many examples of implicit bias that can easily infuse where you're making what you think is an obviously common sense finding of any sort, and you're bringing your subjective own experience. Somebody has to then identify that bias and explain the experience of the vulnerable individual in front of you, which is sometimes difficult to do, particularly when I, as an older white woman, start explaining to another older white person what the experience of a young Black man is with their interaction with police. So I don't know if that's responsive to the question before you, but there's certainly limits and dangers to relying on common sense when you're talking about credibility or you're talking about substantive decision making, which I don't think are quite there when it comes to procedure, but that's for another question.
And Walter, what is your view, having your own lived and professional experience over a number of decades? Anything that you would draw from that in terms of where we are at and where we have to go in bringing our biases and understanding of our biases into applications of common sense and being efficient and common sense cause and effect decision makers?
Well, a couple of things. First of all, I'm glad Carrie mentioned RDS. I think that's a terrific case. It has a great discussion about self-awareness, lived experience, and impartiality. And I'd urge everybody to have a read of that. It's one that you could use as sort of a touchstone for this particular question. The other comment I would make is that there has to be a high degree of self-awareness on the part of an adjudicator. Self-awareness of what your own educational biases are, your cultural biases are, your experiential biases are. You know, the example that I've used in the past when I've done workshops is that you have someone who's in the witness box that doesn't look you in the eye. That does not mean that they're lying. It may be from their cultural background to look a person in authority in the eye is insulting. It's not done, you know. So those are the sorts of things you have to be aware of. And as I think it was Madam Justice McLaughlin in RDS, I can't remember now. It's been a while since I read the case, but as was explained in that case, the fact that you have these perceptions or perspectives that come out of your lived experience, it's not something you can get rid of, but it's certainly something that you should be aware of when you assess credibility, you assess the facts in front of you. So self-awareness, I think, is a very important thing. And again, the comments I agree with. You can't ignore expert evidence, for example, the Saskatchewan case, in favor of your own common sense and expertise. But your expertise should be able to help you assess that expert evidence. And if there are gaps in it, ask the appropriate questions. That's what it's there for. You're not an expert in, you know, if you're a nurse sitting on a nursing panel, you're not there to use your expertise to create the case, to step into the litigation, to step into the field of combat, so to speak. That expertise is there to assist you to reason, logically assess, and bring your common sense to bear on what you are actually hearing. So self-awareness, I think, is an incredibly important thing. There's other aspects that you should be aware of as well, but I think we may be getting into that a bit later, in terms of knowing your parties, knowing It's already been suggested that a simple definition might be what is the logical outcome of your decision? What impact is it going to have? Well, the impacts may be great. There may be a very short-term impact in the case itself, but there may be a long-term impact on the parties, particularly in an environment like labor, for example, where the unions and the employers are frequent flyers, as I like to call them. They constantly appear before the board. So it's not a one-off case as you would find in a generalist court where two protagonists sue each other and once it's done, they never see each other again as long as they live. In the labor environment, the protagonists see each other all the time. They're in collective bargaining. And so the impact of a decision, of a labor board decision may be far greater downstream than the actual case itself. And that's something that the board has to be aware of. The other thing that you have to distinguish is between statutorily created bias. For example, again, the labor board, where the appointees come from the union and employer side, they bring baggage with them versus other environments where appointees may not have any baggage at all other than their own personal lived experience. So that's something else you need to be aware of. Thanks. Those are my comments.
Thanks, Walter. And I'll turn to Jose. But interesting, and we all have baggage. I guess it's just how much of it you can label precisely as labor side or management side. But good observation. Jose?
Oui, bien, je suis tellement d'accord avec Walter. Moi, j'en suis une adjudicatrice et se regarder, la connaissance de soi. Il faut être capable de se regarder d'en haut. Pourquoi tu fais ça? Pourquoi tu penses comme ça? Pourquoi tu as cette réaction-là? Parce qu'on a tous un passé. Il y a des gens qui ont travaillé plus du côté des travailleurs, d'autres du côté des employeurs. Et je pense que c'est inévitable que notre propre personne, notre propre expérience, notre vécu, nos origines, nos croyances, ce sont tous des éléments qui risquent de faire bifurquer un peu ce qui est censé pour le plus grand nombre, parfois d'un côté, parfois de l'autre. Aussi, par rapport au vécu des gens et à leur expérience et à ce qu'ils peuvent penser de ce qui est du bon sens, nous, les juristes, on trouve que certains concepts de droit ont beaucoup de bon sens, mais si on en parle à des non-juristes, eux, ils vont les trouver très discutables. Il y a plusieurs professeurs, on est plusieurs professeurs ici sur le panel, et quand on enseigne, par exemple, en droit du travail aux employeurs, que c'est une responsabilité paritaire, mais que ultimement, c'est à l'employeur que revient la grande responsabilité de s'assurer de la santé et de la sécurité de tous les travailleurs, et moi je disais du stationnement jusqu'à leur cœur. Quand on dit ça aux employeurs, ils n'en reviennent pas. Ils nous disent que c'est impossible à atteindre. Et nous, on leur répond, ben, c'est la loi. Ce sont mes commentaires.
Really interesting questions here in terms of the bias and how to address it. And I would just observe, I'd much rather hear somebody say, have you considered the possibility of this perspective? Or what about this view? That's, you know, as an adjudicator, whether that's coming from lawyers or parties appearing in front of me, or if I'm in a panel of 3 adjudicating, I'll just share, you know, that's an effective way to get the discussion going and to explore. Whereas if somebody just asserts, you know, you ask them a question, well, that's common sense. It's a reflection killer. It's, you know, it stops the dialogue. So it's interesting. We're aspiring to it, and yet it can be a weapon of its own as terminology as well. So thinking about how we can apply common sense in effective ways, we have a couple of questions that have come up both in the chat, I think, and in our Q&A section, talking about, well, how do we distinguish between common sense and this concept of reasonableness that looms so large in the administrative law world? And panel, I guess I'm going to ask you is, you know, how do we think about common sense, both in terms of procedures at tribunals and in terms of the reasonableness that we're always seeking to achieve at a minimum? How do we sort of think about reasonableness and common sense and sort of the procedural outcomes that we're also looking to achieve. Let me turn over to, I'm going to turn over to you, Anita, because you've started talking about some of your procedural experiences. And I think it's really important to hear the examples. And certainly I'm going to once again invite our attendees if you'd like to join in the discussion and throw any examples for the panel to consider. I can see everybody is monitoring carefully. And I'm also going to provide a heads up that one of the last questions I'm going to ask our panelists is what are your most important tips to encourage effective use of common sense in tribunal processes? And I welcome any crowdsourcing on that may come. So I'm giving you a heads up so you have a chance to chime in on that. But for now, reasonableness and common sense and procedural fairness, big concepts. How do we juggle them all?
Thank you, Stefania. So my view is the application of common sense in the context of substantive decision-making is clearly, in my view, even based on our conversation today, more controversial and potentially more problematic than its application in procedural decisions, in my view, and I think as we've heard. Because when we're talking about substantive decisions a tribunal makes, we're often talking about credibility determinations. The cases that I had reviewed on this topic basically suggested, in sum or substance, a decision maker can make common sense credibility findings just so long as the decision is obvious. And of course, then we're back to what is obvious. And each of us thinks that obvious may well be one thing, but we're, as we've discussed now, imbued with our own implicit biases. As I said earlier, something that's obvious to an older white man based on his own subjective life experience may well be quite opaque to a young Black man or to an Indigenous woman or to anyone with different life experiences. It's in the realm of substantive decision-making where common sense can be problematic if it is not culturally competent. However, where I first started talking about common sense in the context of administrative law decision-making, I was focused on procedural decisions. I think common sense is mandatory when making procedural decisions. And it's a lot easier to apply common sense because we are so clearly talking here about fairness. So I agree with Jose about a lot of what she has said at the outset, that the ultimate focus must always be fairness. And I think this is a shared goal we all understand must be the overarching goal of administrative justice. It must be fairness. So what I see in my line of work is persistent denial of procedural fairness in favor of administrative efficiency. So from the perspective of the vulnerable litigant, many of my cases on appeals from various tribunals hinge on arguments of miscarriage of justice on procedural fairness complaint grounds. And where my tribunals get overturned, it is often because a vulnerable litigant was denied that due process. And the reason they were denied procedural fairness is most often because the tribunal is rushing to conclude that hearing due to time constraints, or that it has institutionally mandated certain time constraints, and always appreciating the need for that and the efficiency needs there. But sometimes the institutionally mandated time constraints are simply not feasible for either many cases or the rigid enforcement of these time constraints because the rules mandate them, even where a case clearly requires more time based on unanticipated circumstances that arise in the hearing, will lead to manifest unfairness in the hearing room. So a common example in my world, across the mental health tribunals where I appear, are those cases where a tribunal does not afford a person with a cognitive issue or an acute mental disorder sufficient time to absorb late-served psychiatric reports. So there's a concern for the time of the professional person. You know, the psychiatrist has attended this hearing. We don't want to bring them back. You know, they didn't have a lot of time to prepare their materials. Review the materials now. We're going ahead. We've set this time aside. We've got to make a decision, get this hearing done. And you're talking about someone who's just received a 25-page report and given, 7 minutes to look at it. Or the tribunal doesn't afford a self-represented party an ability to participate meaningfully because of some other rule, even where that rule is created as a fairness protection rule. So for example, when my clients are not well, they may want to talk. They may need to get their evidence out right when they appear before the tribunal. And often they're shut down because there's no onus on them to present evidence. They're supposed to go last if they want to go last. You want to hear the evidence against them first, and that's there to protect them. But at the same time, if they can't say their piece at the outset, they won't be able to remain in the hearing room. They'll be too disruptive and too agitated. So we've got to be flexible, all of which I think of as common sense. We must not be tethered to rigid application of procedural rules that in a particular case will result in unfairness. So I think a lot of tribunals are fearful of being appealed, and that approach can have a paralyzing impact. But at the same time, I worry that our tribunals sometimes don't think enough about how a reviewing court would perceive what has happened in the hearing room, because manifest procedural unfairness is immediately obvious to reviewing courts as it would be to really common, ordinary, or reasonable observers. And I don't want to take up too much time here, so I'll just stop and refer people to, I'm sure you're all familiar with, maybe you're not, longtime favorite case of mine is Sternberg and the Ontario Racing Commission. And if you don't know it, we'll provide you the link to it. But it's a divisional court review of the Ontario Racing Commission that purported to discipline a lawyer for incivility to the tribunal and held a contempt proceeding where the lawyer was profusely apologizing. The tribunal stood up, took a 7-minute break, came back with a 28-page typed single-space for holding him in some kind of contempt. So stuff like that happens. If you just ask yourself, if anyone ever finds out what we did here, would they think that this was a fair or reasonable thing? Anyway, that procedural fairness, I think, is easier to require common sense and not have that tainted by bias or any other major pitfalls.
I might take the opportunity then to go, Anita, to you, Jose, because I think the statement procedural fairness may be an easier place to apply common sense is an interesting one to contrast against what you described, Anita, as the fear that I think many tribunal members have of getting something wrong on procedural fairness and what it takes to make sure that we don't get it wrong. Jose, what are your thoughts on how to apply common sense and achieve outcomes, recognizing we're all in the back of our minds, it's not necessarily so much that we may be reviewed, but really what must we fully do to achieve that procedurally fair outcome?
Merci. Des fois, je pense que dans mon travail, il faut siéger avec le cœur ouvert, même s'il faut décider avec la tête. Alors, je suis d'accord avec ce qu'Anita dit. Il y a une différence importante entre les règles la place du bon sens dans les règles de procédure puis les règles du bon sens dans les dispositions de droit substantif. Les codes de procédure nous le disent eux-mêmes et il faut interpréter la loi et les règles de procédure en fonction de l'objectif de la loi. Et nous, l'objectif de notre loi, c'est l'indemnisation. Mais on n'est pas tous d'accord, les adjudicateurs. On peut avoir des discussions entre collègues. Nous, on administre une loi sociale. Et il va y avoir un collègue qui va dire le mot important là-dedans, c'est loi. Et un autre collègue qui va dire le mot important là-dedans, c'est social. Et de toute façon, les tribunaux supérieurs nous enseignent à ne pas être plus sévères que les tribunaux de droit commun en matière de procédure. Dans un tribunal administratif, à notre avis, les règles se doivent être plus souples pour favoriser l'exercice des droits et pas le contraire. Un exemple, l'ordre de l'administration de la preuve peut être modifié pour que les parties comprennent mieux ce qui se passe et fassent mieux valoir leurs droits. Par exemple, même si quand c'est le travailleur qui est en contestation, en principe, c'est lui qui devrait plaider en premier. Mais on s'est rendu compte que c'est parfois plus simple de laisser l'employeur représenter, commencer. Alors, le travailleur va comprendre de quoi il s'agit, il va mieux pouvoir faire valoir ses droits et c'est beaucoup plus utile que de se lancer dans une longue explication sur ce en quoi consiste une plaidoirie. Et il faut s'adapter. Moi, je pense que le pire mot en droit administratif, c'est la rigidité. Il faut être plus patient. Il faut être plus souple. Et ce n'était pas toujours facile pour moi au début. Il faut être plus flexible. Il faut rester ouvert. Et donc, et on s'en rend compte aussi quand on a devant nous des avocats qui viennent des tribunaux judiciaires et qui se lèvent debout et font des objections. Et nous, on leur dit, oui, je vous écoute, mais vous savez, le travailleur, il veut raconter son histoire, il doit raconter son histoire, puis je vais l'écouter, son histoire. Et donc, toute la procédure, il ne peut pas en avoir du tout. Je comprends qu'il faut qu'on puisse se comprendre, que ça se passe d'une façon intelligible. Je comprends ça. Mais au-delà de ça, je pense qu'il faut aussi s'adapter à qui est devant nous. C'est qui cette personne-là? Par exemple, savoir que cette personne-là, de toute évidence, elle ne sait pas lire. Alors, je dois m'assurer qu'on comprenne bien ce qui se passe. L'ambiance va être bien différente avec un travailleur non représenté qui a de la difficulté à comprendre. Puis de l'autre côté, un employeur très bien représenté avec un avocat qui maîtrise toute la terminologie juridique. Ça ne se passera pas de la même façon quand tu as deux travailleurs non représentés ou au contraire, deux parties représentées par des avocats chevronnés, habitués à notre tribunal. Ça ne se passera pas du tout de la même façon. C'est ça que j'aime de mon travail. À chaque jour, on ne sait jamais comment la journée va finir.
And Jose, this perspective, on any given day, we don't know what's going to happen. What I like is that over the arc of your career, the way you do things is different and changing, and you're constantly reassessing. Walter, I might put this same question to you, but within the lens of, would you say over time as an adjudicator and with experience at multiple tribunals, did your perspective of what is common sense and how that factors into achieving, the reasonableness and how to ensure that outcomes are and processes are procedurally fair, did that change over time for you with experience?
Well, I agree with Jose. It's different in different cases. When I was counsel for the Workers' Compensation Appeal Tribunal, there would be a lot of self-represented folks that file a petition for judicial review. And one of the obligations that they have is to prepare the record for the court. Now, Jose will know this, that compensation files come in boxes. They don't come in little folders. And so for a worker to prepare the record for the court and sufficient copies for the employer and tribunal counsel, and I forget, there were like 5 sets you had to do, was a daunting task. So the first thing I would do as counsel for the tribunal is I'd phone the worker and I'd say, look, if you don't mind, I'll prepare the record and I'll file it on your behalf. And 100% of the time they say, please do that. And that's part of the procedural fairness, even when you're the litigant, so to speak. I mean, as counsel for the tribunal, I was very limited in what I could say on a judicial review in any event. My hands were tied behind my back in many respects, but I would do all these procedural things to make sure that the worker at least was heard, didn't show up in court with no record and have a judge angry at him or her, so it's so that would be one of the things that we would do. The other example that I have from my adjudicative experience, again with self-represented people, is to understand how they communicate. Some can communicate very well in writing because they may get assistance to do that, and poor communicators verbally. So at that point in the hearing, you may want to ask them whether they would prefer to make their final submissions in writing as opposed to forcing them to speak. Another example with self-represented folks, sometimes I would, well, early on, I would try to explain early on in my career, I try to explain to them the process, that first you do some opening statements, then you call your witnesses, and then you do some closing arguments about what you heard from the witnesses. And my experience was that the self-represented person would stand up and they'd tell you their story, and then time to call your witnesses. They tell you their story a second time. Time to make argument. They tell you the story a third time. So eventually, what I started doing, especially if there were counsel on the other side, and I could see that the worker or the employee or the person being disadvantaged, I would say, look, tell your story once. I'm going to affirm you right at the outset of the hearing. whatever you say will be on the recording, and I will sort out the difference between evidence and argument. And I would look at the lawyer and I would say, any problems with this? And usually the answer is no, sir. You know? And so those are the kinds of things you would do to facilitate procedural fairness. Thanks.
Thanks, Walter. And I think those things get easier as you do more hearing work and as you adjudicate more. But I think there's also a window of opportunity for counsel to lead that process in hearing rooms as well, and put out ideas that may not be in the forefront of the adjudicator or the decision maker as, you know, as one possibility to jointly improve processes. I did want to hear from Carrie on this point, and particularly, I think from the academic perspective in a post-Vavilov world, anything that decision makers, decision writers should be thinking about in terms of applying common sense. And in particular, do you think we need to explain any claim of common sense better for a potential reviewing court now that we've heard what we've heard as a result of that trilogy?
Well, just on the last point, certainly Vavilov has tightened up the standards in terms of justification. So if you're relying upon what you call common sense, then you sure as heck better explain what you mean by that, because a reviewing court is going to want to follow your chain of logic. And common sense, as we've talked about, is sometimes in the eye of the beholder. But in terms of, you know, what is common sense from a procedural standpoint, I mean, I think, you know, Jose, Anita, and Walter have pointed out that, you know, really what the law is asking you to do is balance, because common sense from a government organ is based on efficiency. How many people can we get through the system? And, you know, not for nothing, because part of people, you know, going through an administrative process is it's supposed to be faster than going to court. And that's part of justice, is getting a fast decision, but that has to be balanced against an individualized assessment, right? And that's what Baker tries to do. The thing that I show my students at the beginning of administrative law is a documentary called Welfare by Frederick Wiseman. And it's a documentary from the 1970s where he has no commentary. He just sets up a camera and follows people trying to get a welfare payment. And what it shows is just people churning through the system. And one question I often ask the students, how many people did you notice actually getting approved for welfare benefits at the end? And there's one, and it's a 3-hour film going over a series of days. So it just in terms of common sense, you know, what are you there for is to provide benefits. You're not to churn people. So there's that issue. But, you know, before I sign off on the panel, I did want to ask people to think about the idea just in terms of, you know, thinking about common sense and whether it accords with everyone's experiences. What studies are showing, I'm reading a book called Atomic Habits, which apparently is big on TikTok. So I'm revealing a lot of myself here. But one thing that he talks about is in order for things not to be overlooked, to make them a habit, is to bring them to consciousness. So he talks about the fact that in Tokyo, they had workers shout out, you know, okay, there's, you know, the platform is clear, or okay, the train is moving, even though it seems obvious to everyone. And the level of safety just skyrocketed just by virtue of having workers bring those ideas to consciousness and articulate them. And from my experience, you know, student opinion surveys where lots of bias can creep in, what they've found is just simply having a statement in the front of the survey saying, you know, oftentimes people are affected by unconscious bias in filling these out. So just be, you know, sensitive to issues of gender and race and all of that. Even just putting that statement has caused the levels of reliability of those surveys to go up. So whatever you can do as decision makers to consciously think about those questions will have an amazing, likely an amazing effect on you interrogating what common sense is. So that might be something that you want to think about.
Thanks, Carrie. And we're closing in on our time for today's session and our interrogation of common sense, which I love as a phrase. So I'm going to take the time that we have left to come to the question that I promised we come to, which is I'd like to do one last roundtable among our panelists, and I'd invite our attendees to participate in the chat if they'd like. And that is, what would be your most important tip based on your experience or your request to tribunals to encourage the effective application of common sense in administrative law processes, in tribunal processes? And as I said, I welcome any thoughts that may be thrown up in terms of here's one thing that would be impactful, or here, Carrie, as you've suggested, bringing to the fore this explicit reminder to do something or that something's about to happen. Let's turn over to Anita. I'm going to give you the first word on this. As I said, as the sponsor of today's program.
I'm so honored. I'm so honored by that. And I've learned so much, and I am by far the weakest link in this stellar, exceptional group of incredibly thoughtful people. We've heard about the elevator pitch. How would you describe something between floors and an elevator? And I think we've all heard the advice, clear writing, clear oral advocacy. You can test it out on a 12-year-old, see if they understand what you're saying, your theory of the case. I think it wouldn't hurt adjudicators and tribunals to ask themselves, what I'm about to do, what's happening in this room that I'm responsible for, would this make sense to a 12-year-old? My children are older now, and I lament that a little bit, because when I had a 12-year-old son, he was the perfect barometer for everything that I wanted to argue. I would say to him, listen, son, he'd say, what's happening today? This is my case. He'd say, well, that doesn't make sense for this reason or that reason, or that's not fair. Or how did that come to be? And I'll just give you one very quick example. Many, many years ago, one of the tribunals I appeared before directed my client to sit in a particular chair in the hearing room, and he had sat down in another chair, and he was told to get up out of there and move. And when we asked why, we were told the tribunal's policy is the mentally ill person at the center of the controversy must not sit beside the court reporter who's a member of the public. And of course, this tribunal in this hearing was to determine whether or not the person had mental illness and whether that posed a danger. But the institutional presumption was of dangerousness because the person was not permitted to sit beside the court reporter, but they were supposed to sit beside me, not a member of the public. But I think if they had just said to a kid, look, the mentally ill person can't sit beside the court reporter, they have to sit somewhere else. What do you think that means? That a kid would say, it means they're afraid. They're afraid of him. They're afraid he's going to do something. And the bias is immediately laid bare. So I don't think it's the worst thing to ask yourself, how would a child see this, or a preteen? Try things out on people. I think it works for almost everything. That's my common sense, which is perhaps childlike, but I don't think it would hurt. So that's it.
No, that's very practical and hands-on. Walter, you've given us already some concrete examples of what you've done in your hearing rooms before. Any final tips or tricks?
Well, I like the child example, because that's when I did workshops for BC CAT, when we did fairness, that's the first question we always started with. Put yourself in the shoes of your kid and ask yourself, are you being treated fairly, especially by your parents? So that's a good barometer. In terms of any tips or whatever for use of common sense, particularly in a procedural sense, I think I've mentioned some already. And know your parties. Who are they? Are they represented by competent counsel? Because sometimes they're not. Are they self-represented? Are there ESL issues? Can they express themselves verbally or in writing? Are they frequent flyers? Know the issues. This is an important one. The statutory issue, the one you're charged with, that one you're going to know because it's set out in your charging statute and in the documents before you. But what does the whole thing turn on? There's going to be, you have to drill down and find out what, use your common sense. Perhaps a better question is, what's really going on here? Okay, that might be the better question. Appreciating the larger picture, I've already mentioned. Is this a relationship situation? Is this a one-time dispute? Know when to apply the appropriate procedural pressures. We've talked about, other panelists have mentioned that you kind of bend over backwards for people who are disadvantaged or people who are having a difficult time self-represented with understanding the system. But there are points, and this is where your adjudicative experience and common sense comes into play, where applying the right amount of pressure by actually enforcing a rule may bring about a desired effect. So I've an example I had when I sat on the Human Rights Tribunal at a case that involved the strata, smoking area, disabilities, COPD. Of course, the smokers are disabled also because they suffer from an addiction. And there was a controversy as to the location, and the complainants were there. They had refused all discussions of settlement, didn't want to participate in any sort of mediation. They wanted to poke the Strata Council in the eye with a great big sharp stick. So the hearing started, and the complainant wanted to call some evidence. And the first thing she said is, I'd like to call some evidence, and my witnesses are available by telephone. I said, by telephone? And she says, yes, one is currently living in Alberta. And the other one, well, she's got a doctor's appointment later today, so she found it inconvenient to come downtown to testify. And our rules provide that if you're going to have a request to have witnesses testify by telephone, then you have to give a certain amount of notice, and the technical arrangements have to be made and all the rest of it. And of course, here we are, start of the hearing, and this is the first anybody's hearing. And of course, there's a lawyer on the other side who's beside himself, having heard this request. And I'm thinking, well, what do I do here? To me, the case is crying settlement. This is a case that needs to settle. So I hear some argument about whether or not there should be evidence presented by telephone. And I said at that point, well, I'm going to reserve my decision on whether or not I'm going to permit you to call your evidence by telephone, because you knew the rules, you didn't follow the rules. So what we're going to do is we're going to proceed, and you're going to give your evidence, and then I'll decide whether you're going to be able to hear evidence by telephone. And then I looked at the complainant and I said, would you like a mediator? And she said, yes, please. So knowing the moment, knowing the timing sometimes is really important. Mollycoddling all the time does not necessarily produce the just result or the good result in the long term. So when she asked for a mediator, I went upstairs to one of my colleagues and I said, are you available to do a mediation? The case was done in less than an hour. Everybody was happy with the settlement. So the right pressure at the right time for the right reasons. Those are my comments.
Thanks, Walter. And I've got about 30 seconds for you, José, and 30 seconds for you, Carrie. Why don't I go to you, José, first? José, votre conclusion aujourd'hui.
Puis, il y a quelques semaines, je discutais avec ma présidente et d'autres collègues à propos de ce sujet, et elle disait qu'elle se rappelait les propos d'un juge qui lui disait que lorsqu'il signait une décision, il s'assurait évidemment qu'elle soit basée sur la loi, les principes de jurisprudence et la preuve faite, mais qu'il avait aussi comme objectif de s'assurer qu'elle soit claire et compréhensible pour son père qui était cultivateur. Et ça, je trouve que ça a bien ce bon sens. Merci beaucoup.
Merci, José. And finally, Carrie.
Well, maybe apropos of nothing, but I'm a grievance officer for our union, so I do that part-time now. And we were telling war stories, and they were talking about one labor arbitrator where the parties were squabbling over like $100 or $200 issue. So the arbitrator took the lawyers out for lunch and said, you know what I'm going to do is I'm going to write a check for this, and I'm going to bill both sides for $100. And that's how it's going to be. That's the decision. So sometimes, common sense does prevail, decision makers, I mean, God bless you for doing that and getting to, the real issues between the parties. So that's my contribution for the end.
Well, and I want to say thank you to all for your contributions. We are just about at our time, and I just want to reiterate how grateful I am for I'm sorry, can you still hear me? Okay, I just got an odd message and I thought I might be kicked out. Grateful that you accepted the invitation to join us here today and to share your brilliant thoughts and your just impressive experience with all of us here today. I'll share with you my takeaway. Know yourself, know your parties, and know your purpose. I've gotten a little bit of that message from all of you, and those are good reminders to take forward. Thank you for identifying those opportunities to improve administrative processes. As a final word, I'm pleased to announce that in lieu of speaker gifts and as a token of our appreciation, CCAT will be making a contribution to the National Self-Represented Litigants Project in your honor. So thank you, all of you, and just noting that. To all of our attendees, thank you for your questions, your comments. Please watch for a reading list to be circulated from CCAT in the coming days. And also, if you have not registered for subsequent sessions in the CCAT Symposium, there's certainly time to do so. The next session is Critical Theories for Tribunals with Donna Young, Patricia DeGuire, and Odelia Bay. So join our expert panel next week doing a deep dive into critical theories and how they impact the lives of those appearing before us. So thank you all so much. 12:31, not quite on time, but close. Enjoy your wonderful rest of day. Thank you all.